Hi, this is Jasmine Tohidi, and this week I'm going to discuss the Form I-751, which is a petition to remove conditions on permanent residence. What is that? It's when you get your 2-year conditional green card based on being married to a U.S. citizen less than 2 years at the time you receive the green card. You'll have to petition to remove those conditions in order to get your 10-year green card. There's several categories which you can apply for. The first and easiest is what's called the joint filing. A joint filing means you and your U.S. citizen spouse are still together and you're filing jointly. When do you file? You have to file within the 90-day window of when your 2-year green card expires. Do not apply too early. If they receive your petition before the 90-day anniversary, they will accept it but ultimately deny it. If your child adjusted status and received their green card at the same time as you, the 2-year green card, or within 90 days of the time that you received it, you only have to file one 751 and it'll include both of you within that petition. So what happens if you're no longer with your spouse or they've passed away? Well, you can file what's called a waiver. The first part of the waiver is if your spouse passed away during the 2-year conditional period. You'll still be required to demonstrate that the two of you married out of love and not for an immigration benefit. You'll have to include the death certificate. You do not need to wait for that 90-day window. You can apply before that, and that's for all the waiver categories. A lot of people get mistaken that you have to wait for that 90-day period before your 2-year green card expires. That only applies to joint petitions. What's the next ground? The next ground is that you divorced, and that means you have a final divorce with your U.S. citizen spouse. You still have to show that you entered that marriage in good faith. What does good faith mean? It means that you married that individual out of love. So for the period of time that you have documentation, you have to still show that you resided together, that you had joint bills, or basically that you two married out of love, but now you've had divorce. This is a situation that very commonly comes up with my clients, which is they have separated from each other, but the divorce is not finalized. You can apply under a separate category, and when your divorce decree is finalized, you can switch back to the divorce category. What are the other categories to apply for? The biggest one is Violence Against Women Act. That is for both men and women when they've been abused during the 2-year conditional period. A lot of people get confused between that and the I-360 VAWA application. If you already have your 2-year conditional green card, you do not need to reapply for a new green card with the form I-360. You file the I-751 and you check the box under extreme cruelty or battery from your U.S. citizen spouse. You still have to show that the two of you married out of love, but then on top of that, you have to prove that they either physically abused you or subjected you to extreme cruelty. At that point, you submit the petition by yourself. Again, you do not need to wait for the 90-day period before your 2-year conditional green card expires. I've done a lot of cases where we file 6 months or 7 months into the conditional period or 1 year into the conditional period because the spouse has become abusive very quickly into the 2-year conditional period. The last one, the waiver category that's not used very often, is the extreme hardship category. So what do you have to show? Extreme hardship is a high concept, so it's not just the regular suffering someone would have if they have to return back to their home country. The other part that people don't pay very good attention to is the extreme hardship has to occur within your 2-year conditional period. What does that mean? So let's say you got your green card in 2018 and it's now 2020. You have to show some period between 2018 to 2020 you suffered extreme hardship. So a lot of times things happen after the conditional period, but USCIS cannot consider that. And again, for the extreme hardship category, you do not need to wait for the 90-day period to apply. You can apply early. I hope this was helpful. If you do have a 751, make sure to apply on time. Read the instructions, which give you a lot of guidance, and you may want to see an immigration attorney. I hope you guys have a wonderful weekend. Thank you so much.